Distinguished guests, dear colleagues, dear President of INSOL Europe, Avvocato Giorgio Corno. First of all, I would like to express my sincere apologies for my absence and for not being able to join you in person in this prominent moment of INSOL Annual Congress. From the first announcement, I expressed my interest and wish to attend and be there with you all, especially as it is hosted in my homeland and as an attestation of appreciation to the magnificent work done by Giorgio Corno, to whom I reiterate my apologies once again. The theme of this Congress and the topics that have been chosen are fascinating and challenging for us, both as practitioners and as representing institutes, as to the competences that they need to be gained through valid CPD programs and innovative legislation. Let me share with you some features of our profession and the specific challenges that we are addressing at Italian level. The CNDCEC, my institute, is the national body representing the accounting profession in Italy, regulated by a state law, the Law 139 of 2005. By saying accounting profession, we mean all the wide range of professional activities that are encompassed in this very broad area. The correspondence in other countries or jurisdictions are indeed very different. It includes auditing and attestation, business reconstructing and strategic advice, M&A and extraordinary operation, corporate notary, tax consultants, tax management and litigation, and all the insolvency engagement. In this case, more specifically, our members are curators, insolvency and crisis restructuring administrators, commissioners, liquidators, assignee of executive and judiciary cells appointed by the court. In the Italy system, these activities have been always assigned to our registered members, and it's not because we made a special lobby to obtain it. It's a deep understanding by the Italian legislature already in 1942 that the complexity of the different insolvency situation and procedures requires not only legal knowledge, but an interdisciplinary approach, which includes also an understanding of finance and auditing. As one of the most relevant aims of an insolvency legislation is to detect the crisis situation at the early stages and propose solutions to manage the situation and propose alternative schemes to redress the crisis. It's well understood how our profession can be involved in these operations. This has been kept and enhanced also in the most relevant reforms of 2006 and the one that has just been enacted. I believe at the international level it's a unique approach, and I'm very proud of this. Of course, it entails a collaboration with expert lawyers, and the best team is usually made of both these professions. In order to become commercialisti and therefore insolvency practitioner in Italy, one needs to achieve, first of all, a university degree in business economy and business administration. Secondly, complete 18 months training period with a professional who has been enrolled in the register for at least 5 years, pass a specific state examination, and enroll in the register. Today we have overall 120,000 registered members. Insolvency practitioners must also be enrolled in a specific register. In particular, those carrying out activities of management and control in insolvency procedures must be enrolled in a register held by the Ministry of Justice, which counts today about 13,000 members, of which 90,000 are commercialisti, 75%. Experts in negotiated settlement of crisis are also required to be enrolled in a specific register held by the Chambers of Commerce. As of July 2024, and 80% of the 4,000 registered members are also commercialisti. Mindful of the increase and the relevance of cross-border insolvency issues, CNDCEC has decided to establish 5 years ago a special working group that we call Observatory, dedicated to the specific professional area. The aim of this observatory is to share research, publish dedicated articles, and propose specific CPD courses on transnational insolvency to our members and to lawyers. I already had the chance to appreciate the proposed initiatives as an external to CNDCEC's board, but as soon as I entered, I thought it was of absolute relevance and enhanced this area of activities. I wish truly to thank Luciano Panzani, who chairs this observatory, and Giorgio Corno for their dedicated contribution. Without them, none of the publication and courses would have mattered. In the same direction, we decided as CNDCC and INSOL Europe to sign a cooperation agreement in the reciprocal understanding of our common commitment to contribute with our institutional endeavors, resources and capacities to address with the key stakeholders the criticalities and the prospective solutions that can be taken into consideration. This is especially relevant as we are heading to a new European phase and with the traumatic and systemic situation that we are living due to the Middle East crisis and the Eastern Front, Ukraine and Russia. Our efforts, and I would say daily efforts, are today focused on a number of areas where CNDCC has truly proved to be considered as a relevant interlocutor of the parliamentary commitments and Ministry of Justice, the two players where insolvency legislation is decided and written. Here are the most focused ones: the negotiated settlement and the new tools provided for the new Code of Corporate Crisis and implementation of EU Directive 2019/1023. The aim is to enhance models for the restoration or rescue of enterprises through early warning tools, which facilitate the continuance, the going concern of their activities, preventing the insolvency statement and thus avoiding their liquidation. On the other hand, enterprises that are not suitable for restructuring are timely liquidated to avoid any ineffective restructuring that could only worsen the debitor's condition of financial distress, with further damages for creditors, for the other parties involved in the restructuring process, and for the economic system in general. Since SMEs are the driving force of our economy, the new code recompenses their going concern. In this perspective, the strengthening of their organizational structure aims at avoiding situations of financial distress or risk for going concern, whose value is recognized as fundamental. In this way, a preventive action of monitoring by the corporate oversight bodies is mandatory. There are also some innovative provisions aiming to preserve the value of going concern, also when the crisis has turned into insolvency, when the enterprise proves to be sustainable, for example, capable of generating profits again within a reasonable time frame, coinciding with the duration of a restructuring plan. The new system highlights the need to rely on professionals to avoid dissolving the value of the enterprise. The fundamental role of our categories played in different situations and times is through the crisis. For example, both Article 2086 of the Italian Civil Code and Article 3 of the Crisis Code are aimed at preventing crisis and then maintaining the values of the enterprise. A duty to establish appropriate procedures to grant effectiveness and efficiency in the management of risk and of the system of internal control, as well as the completeness, timeless, and reliability of the flows of information across the corporate functions and with the functions of other companies of the group, and to identify index and parameters allowing to recognize early warning signs. A structure may be considered solid according to the nature and size of the enterprise when it allows to monitor the main financial indicators and timely detect elements of risk. The innovation introduced are quite evident and involve not only the skills of the legal expert, but also experts in economic business science called upon to design the concrete content of the organizational, administrative reporting structure within the advisory function he or she provides to the enterprise. In Italy, a major role in the timely detection of financial distress is played by the oversight body required by the law to control appropriateness and effective function of the company's organizational administrative reporting structure and to report and financial unbalance to management so that they may take action accordingly. According to the Article 2403 of Civil Italian Code, the Collegio Sindacale supervises the adequacy and effective functioning of the structure considering the size, complexity and specific features of the company, paying attention to the completeness of the existing corporate functions, to the separation and concurrence of liabilities in the exercise of their functions, and to the definition of the powers of each function. Once the Collegio Sindacale have assessed the adequacy of the internal structure, also for preventive purpose provided by the Article 2086 of the Italian Civil Code, they must regularly supervise its creation and the appropriateness of the system adopted to achieve the required outcomes, reporting or requiring that necessary adjustments are made. It's not an occasional activity, but it's carried out on a continuing basis throughout the engagement. In this context, Article 25, paragraph 8 of the new Code of Crisis provides that the Supervisory Board shall report on the existence of preconditions for submission of the application for negotiated settlement and deploys its effectiveness. In the context of corporations and cooperatives' financial distress, reporting and precondition indicating serious financial imbalances that could induce to assume an impending crisis. The Collegio Sindacale and the statutory auditors play a crucial role in that they shall present such reporting within 60 days from the time they become aware of such conditions. We have dedicated efforts to introduce a very relevant change in the liability system, which has been approved a few weeks ago by introducing different brackets according to the level of remuneration. Remuneration up to 10,000 euros, 50 times the remuneration. Remuneration between 10,000 and 50,000 euros, 12 times the remuneration. Remuneration over 50,000 euros, 10 times the remuneration. This system allows the auditors to know the financial risk in which they incur and then to foresee an adequate insurance coverage and also to be aligned with other European schemes. The expert in attestation of recovering schemes is a role that has been introduced by the reform of 2006. As a professional specialized in restructuring who needs to be enrolled in a professional register and in the register of statutory auditors. Since 2006, our category has devoted considerable efforts to play a crucial role in the reconstructing of companies in distress. It consists in a general judgment on the truthfulness of corporate financial information and the viability of the restructuring plan, and then to prognostic judgment which require technical skills typical of our profession. The Code of Crisis stresses the relevance of the restructuring plan, but provides indications also on its content, regulating the activity not only of the expert in assurance, but also of the advisor. For example, the party in charge of preparing the restructuring plan. In the light of this important reform, I can then conclude that among the professionals required to deal with the company's financial distress, commercialisti play a central role, a main role. Judicial Commissioner, in addition to supervising the procedures, the Commissioner can now support the debtors and creditors in negotiation of the plan for formulating where necessary, suggestion for its drafting. Likewise, the Judicial Commissioner can also support the debtors and creditors in negotiation of any changes to be made to the plan or proposal. Also in this case, the technical skills of business economists are emphasized, all these procedures. What I wanted to highlight is not the technical aspect and details, as I'm sure you are the most experts gathered here to learn and gain additional knowledge, but to emphasize why our profession is involved. What are the challenges that, therefore, we face in education, ethics, and being at peace with the imperative of digitalization and global risk and crisis that inevitably impact of our system, made of SMEs and local but internationally influenced enterprises. I wish to thank you all for coming and sharing for your dedication and contribution to our European community of insolvency procedures, enjoying our fantastic shores, landscape, and cuisine of Sorrento. Thank you all.